You're watching The Legal Breakdown. So, Glenn, a federal magistrate today approved a request by special counsel Jack Smith. Can you speak on what happened here?
Yeah, so the prosecutors applied for what's called a protective order. And what they were seeking to do is basically have the judge order Donald Trump to keep his big mouth shut because the prosecutors are giving over discovery. That is, all the materials, the reports, information about the investigation, the witnesses to Donald Trump's defense attorneys. And the last thing the prosecutors want is for all of that information to then sort of, be thrown out into the public square by Donald Trump so his supporters can do things like harass, intimidate, and assault the witnesses. We know how Donald Trump misuses information. So this protective order was the prosecutor's way of saying, look, judge, order Donald Trump and his defense attorneys and his co-conspirator, his co-defendant, Walt Nauta, not to disclose, not to post, not to disseminate, not to talk about any of the information that the prosecutors are obligated to give him in discovery.
So, this raises the obvious question here. If Trump and his co-defendant Walt Nauta do disclose any sensitive information that was obtained during discovery, what could happen to them?
Well, let me read from the order itself. It says, quote, a knowing violation of this order by the defendants, the defense counsel, or any authorized person may result in contempt of court or other civil or criminal sanctions. So that means they could be fined, they could be held in contempt, and in theory, Donald Trump, if he was the offending party, if he was the one who leaked it, could be imprisoned for a period of time. The other thing it could do, Brian, is it could create a record of Donald Trump's inability or unwillingness to abide by conditions of release set by the court. And that is the kind of record that can build toward pretrial detention. I don't expect that will happen here, but let me tell you, if Donald Trump was just a run-of-the-mill guy like you or I, we could very easily find ourselves sitting in a jail cell if we violated a protective order.
Yeah. Glenn, is it unorthodox that the DOJ's request here would be granted? Like, does this put Trump on his heels, or is this pretty much par for the course?
It's pretty routine for prosecutors to request protective orders when they're giving over sensitive information. One of the things the prosecutors put in the motion seeking this protective order was pretty interesting, and it's kind of unusual in these protective orders because let me just set it up. Usually, when we indict somebody, then the next step is we begin to give over all the discovery and the investigation is done, right? The indictment has been returned by the grand jury, and now we're moving toward trial. But in the motion seeking this protective order, the prosecutors said one of the reasons we don't want Trump and company disclosing any of this stuff is because it could impact ongoing investigations and identify individuals who are not yet indicted, or words to that effect. That definitely piqued my interest. That was a shot across the bow saying, you know what? We are not necessarily done investigating your crimes. We're not necessarily done investigating possible co-conspirators. So, look out. There may be some superseding or additional indictments coming down the road in this case.
Now, is this the only part of the trial that Bruce Reinhardt, he was the federal magistrate that approved this order, is this the only part of the trial that he'll preside over before Judge Cannon then comes and takes over?
Yeah, it's a great question. And in part, that's up to Judge Cannon. So let me tell you the way it ordinarily works. And I spent a lot of time in federal court, and I talked to federal judges about their ordinary practice. So usually once a case lands with a judge, a permanently assigned judge, in this case at the moment, it's Judge Cannon, matters don't typically get kicked back to the magistrate judges. The magistrate judges are not full judges. They're not presidentially appointed. They're selected by the other judges in that federal district. And I would say they ordinarily don't kick stuff back to the magistrate, except when they do. Each jurisdiction, each federal district has its own practice. I will say most judges, Brian, once they assume responsibility for a case, handle all of the matters, including motions for protective orders. But sometimes the federal judges will feel like, well, you know what? That's a relatively low level, and I'm going to use the word menial task. Let's go ahead and kick that back to the magistrate and let them handle it. That right now is within the discretion of Judge Cannon. Let me give you one other example. If a judge is presiding over a case and it looks like that case will result in a guilty plea, sometimes the judges will kick it back to the magistrate to take the guilty plea, and then they will take it back for purposes of sentencing. So it really is up to the discretion of the judge. And we all know how Judge Cannon has dealt with discretionary issues. She has been found to abuse her discretion previously by the 11th Circuit Court of Appeals.
Do we have any indication here as to how much of the pretrial motions, how much of this pretrial period she's going to kick back to the magistrate versus how much she's going to take on herself?
Absolutely none. We will learn more each time a motion is filed by one party or the other, the prosecution or the defense. And then we just have to wait and see if Judge Cannon kicks it back to the magistrate or she holds on to it and decides the motion herself. As far as I'm concerned, Brian, the more she kicks back to the magistrate, the better, because you can't reasonably question the magistrate's impartiality, but I contend you can reasonably question Judge Cannon's impartiality, given her history of missteps in this case. And being able to reasonably question a judge's impartiality is what requires the judge to disqualify themselves. Of course, I know I'm kind of beating a dead horse now because Judge Cannon has opted not to do that thus far. And we are in this wait and see posture to see whether special counsel Jack Smith files a motion seeking recusal, seeking disqualification.
Glenn, during our last episode, we spoke about that roughly 10-day period where the DOJ would have to request that Judge Cannon recuse herself. Is there any indication that they've done that yet, or any indication that they may not be doing it conversely?
Yeah, that's a great question. I don't think that's a motion that would be filed under seal. In other words, a motion that would be hidden from public view. I think if Jack Smith decides to file the motion to try to first have Judge Cannon remove herself, recuse herself, and if she refuses, if she denies the motion, then Jack Smith could take it up to the 11th Circuit Court of Appeals. There's no indication that it has been filed, and I think it is anybody's guess as to whether Jack Smith will decide tactically it's the right thing to do. I would maintain that in one of the most consequential criminal prosecutions in our nation's history, you can't just sit back and hope for the best when Judge Cannon has already abused her discretion and acted in a way the law does not permit, to do an enormous benefit for Donald Trump previously in this very matter. So I am hoping that Jack Smith files the motion, but at this point, it's anybody's guess.
This is a little bit in the weeds, but do you think that there might be something to this idea that the reason that this federal magistrate, Bruce Reinhardt, that he has this latitude here to deal with these pretrial motions might be because while they figure out the Judge Cannon thing, she might take a little step back out of the spotlight as they kind of decide whether or not she'll recuse or be removed or then be replaced?
I think that's some great informed speculation. I think if there is a debate going on, and what I will tell you, and I know this firsthand, judges talk to one another, judges give each other advice, both solicited and unsolicited. Often every judge thinks they know best. So it wouldn't surprise me at all that in this interim period, when they're trying to decide what to do, and while they are awaiting a possible recusal motion from Jack Smith, they're taking the safer course and letting Magistrate Reinhardt decide the issues that, he can appropriately decide, before we ultimately see how the judge assignment settles out.
Okay. And one more question, and we did speak about this in the last episode as well, but I just want to dig into this idea here. Do you think that there is danger in Jack Smith kind of moving forward with this request for Judge Cannon to recuse herself, in that if she ultimately denies it, then she'll be a little bit more biased as the result of this failed mutiny against her?
It's something that I think prosecutors are always cognizant of. I have had judges make incorrect decisions. Full disclosure, as a prosecutor, I'm sure I've made plenty of mistakes. I made plenty of incorrect decisions myself. But when I saw a judge do it, I had to ask the judge to reconsider, and I had to bring to the judge's attention why I believe, for example, in accordance with prevailing case law, what the judge just did was wrong. That's an uncomfortable moment. You don't like to criticize a judge, but as prosecutors, you put on your big boy pants, your big girl pants, and you have to stand up for what's right, even at the risk of having, the judge irritated at you. Now, I will say in my experience, judges usually don't hold it against you. But my concern is Judge Cannon has already done something that the law did not allow, and she did that thing to benefit Donald Trump in a way that was an abuse of her discretion. So is it a stretch to sort of be very concerned about how she will react, how she will respond if Jack Smith files a motion to have her recused because her impartiality can reasonably be questioned? I would have a legitimate concern about that, but it wouldn't stop me from doing what I believed was the right thing to do.
An abuse of her discretion, by the way, as judged by Republican appointed judges on the appeals court in the 11th Circuit Court of Appeals. So this isn't just a bunch of radical leftists saying that she's unqualified here. It was her own colleagues appointed by people in the party that she's a part of that came forward and said what she did was inappropriate by virtue of interfering on Trump's behalf.
Two of those judges were appointed by Donald Trump.
Right.
And they smacked her down for doing an unlawful favor for Donald Trump.
Yeah. So as we continue to stay on top of this stuff and wait to see whether the DOJ does push Judge Cannon to recuse herself or ultimately does ask that she be removed and replaced, we'll stay on top of this stuff. And if you want to follow along, make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.